Pop up. Yes. Don't press nothing on the side. Okay, because yeah, see. Start video. You can straighten the button. I see what's straighten the button on your phone. Press it to the side. These things like, oh, yeah. Better 2 o'clock.
A quick announcement to everyone. The judge will be starting very shortly. She's running a little behind. So just to put everybody on notice, we'll excuse me, we will be starting shortly.
Okay, thank you.
You're welcome.
Help me.
Right there.
Now that one. Here we go. Play it one time. Now that one.
I'm tired.
Good afternoon, Your Honor.
Good afternoon. Are you able to hear me? This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and today is November the 8th of 2023. All defendants, you have an absolute right to remain silent, and anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding. All participants, this proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch. Ms. Bridgewater, what is my reset date?
Your Honor, it is going to be November the 21st.
All right, thank you. Okay, so those who receive a signature bond today will be reset for the notice. Those who receive a surety or cash will be reset, as Ms. Bridgewater just indicated, to the November 21st State All-Purpose Calendar. All right, who do we have first?
Good afternoon, Judge Williams. This is position 12, Taylor.
12. I'm sorry, and I don't have the calendar.
I'll get you one over. Do you want me to go ahead and call it?
Let me see. It should be in my email. Oh, 1 second. 12 Taylor. Okay, I've got it. Give me one
Okay.
second to open. Thank you, Ms. Bridgewater.
You're welcome.
All right. Are you Nikita Taylor?
Yes, ma'am.
All right, your case is 23 CR 0069554J. You're charged with simple battery, theft by shoplifting, and obstruction with the offense date of November the 7th. You understand your rights?
What do you mean my rights? All I know is that I didn't.
You have no, don't say too much. You have a right to remain silent and you have a right to an attorney. Do you understand that?
And so,
I'm sorry, do you understand that you have a right to remain silent and you have a right to an attorney?
I don't get that.
Okay, well, we're gonna move forward. I've informed you of your rights. Mr. Howard, can I have the history, please?
My bad, I was seeing things. 28 total. Last arrest was March, felony obstruction. 2022.
Okay.
I think it's more, Your Honor.
No, I wasn't cutting him off. I'm
Oh.
sorry. Go ahead.
Oh, yeah. 2022, failure to appear. 2022, trespass, obstruction, conviction. 2022, trespass, conviction. Several failure to appears between 2021 and 2022. 2021, simple battery, obstruction, conviction. 2020, simple assault, conviction. 2019, failure to appear and trespass, conviction. And 2013, simple battery, conviction. Level 4.
Level 4 is reporting once a week?
Level 4 is actually ISP.
Okay, understood.
Did you get my email?
I did. Understood. All right, Mr. Walker, please proceed.
Yes, Your Honor. In this case, law enforcement was dispatched to the Quick Trip gas station located at 630 10th Street, where they spoke to the staff at that location. They advised that the defendant was caught shoplifting cookies and wine from the location. One of the employees by the name of Tiffany Evans did attempt to prevent the defendant from leaving. At that time, the defendant did take a bottle of wine and swing it at the defendant's head. Eventually, law enforcement was able to detain and arrest the individual. She did resist arrest. That's the basis for the obstruction. The state's recommendation is going to be $1,000 surety bond on each count, a total of $3,000 surety bond. Stay away from the incident location, which is the Quick Trip. No contact with the victim, Ms. Tiffany Evans. No weapons, drugs, or alcohol while out on bond.
All right, and I'm sounding for Ms. Evans at this time. Are you present and wish to make a statement? Okay, hearing none. Ms. McLeod, I'm assuming this is your client?
It is, Your Honor. Good afternoon.
Good afternoon. Please proceed.
My client is 39 years old, Your Honor. She is currently unemployed and currently homeless, so she's not in a position to make bond, Your Honor, and I would ask the court to take that into consideration in setting her bond. She has been unemployed for a very long time, she tells me, Your Honor, and she doesn't have anyone who can help her with posting bond. She denies that she attacked anyone or that she stole anything, Your Honor. And she also tells me that she has been attacked in the jail, so she's not feeling very comfortable there. I would ask the court to give my client a signature bond. I know that she has some history, but I believe that her history is not such that would prevent her from, I don't recall hearing any FTAs, Your Honor. So I would ask the court to consider giving her a signature bond, given her indigence. Nothing further, Your Honor.
I'm almost certain pretrial said several
There were
FTAs.
FTAs. All right, defendant
I
will
didn't
receive
hear any.
defendant
I
will
didn't
receive
hear any, Mr. Walker.
okay. Defendant will receive a $2,000 split bond. It's going to be 500 surety on count 1, 1,000 SOB through the jail for count 2, and 500 surety for count 3. So she's going to have $1,000 surety bond and $1,000 SOB through the jail. She is to absolutely stay away from that QT, have no contact with Miss Evans, and have no alcohol, no drugs, or weapons as a condition. Is there anything additional?
Nothing additional. Miss Taylor, you have the right to remain silent.
All right, Ms. Taylor,
Let's
please don't
exercise
say
the right.
anything. Your attorney will give you a call.
What I'm trying to tell you is the fact that I haven't hit nobody and all my
Okay.
I already said that, Miss Taylor.
all my belongings were store-bought.
All
Everything
right.
I had was store-bought. I didn't even have any alcohol.
All right. Understood.
And the man in the store hit
Taylor,
me.
you have a right to remain silent and your case has been decided. If you have additional questions, you can speak to your counsel after this hearing. All right. Best of luck to you. Who do we have next?
Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may. And please reach out to Ms. Taylor. She
I will,
appears to
Your
have
Honor.
quite a few concerns. Take care, Ms. McLeod. Have a good day.
You too, Your Honor. Thank you.
All right. Who do we have next?
Position 8, Nixon.
All right, good afternoon. Are you Kathy Nixon? Your case is 23 CR 006952A. You're charged with harassing communications. Do you understand your rights? Is that a yes?
Yes, ma'am.
All right. Mr. Howard?
Fifth arrest, 2018 assault conviction, 07 obstructing judiciary. This was level 3. That's it.
And for a while, I'm going to ask you what the levels mean. Level 3 is reporting how often?
I think once a week. I don't have the paper with me. I'm gonna have to send it to you.
Okay, understood. Mr. Walker?
Yes, Your Honor. Law enforcement was dispatched to 1910 Waycrest Drive, where they spoke to the victim, Mr. Lewis Lipson. He advised that he and the defendant used to be in a romantic relationship several months prior. The defendant has continuously and repeatedly reached out to the victim by texting him that she was going to kill him and his family, including his new girlfriend. With that being said, the state is asking for a $1,500 surety bond. No contact with the victims, Lewis Lipson and Ms. Lucia Hubbard. Also, no weapons, drugs, or alcohol while on bond. We obviously will sound for the victims, Mr. Lewis Lipson and Ms. Lucia Hubbard. I would ask for a stay away. It's my understanding that they live in the same apartment building, but he lives on the first floor. I'm not sure if it's possible for her to stay away from his particular unit. I wanted to make the court aware.
Do the best to stay away. All right. I'm going to sound for Mr. Lipson or Ms. Hubbard at this time. All right. Hearing none. Is it Ms. Atay?
Hi, yes, Miss Atai.
Ms. Atay, please proceed.
Okay, good afternoon, Your Honor. My client is 64 years old. She lives alone and has a caregiver visit her 3 times a week. She is disabled. She's 70% blind and suffers from several severe health issues. She has lived in Georgia for 4 years. She moved here to be with her daughter, who attended Clark Atlanta University. She denies the allegations in the warrant, states that she does not know Lewis, what's his name? Lewis Lipson or Lucia Hubbard. She called the police because her apartment was broken into, and the officers arrived and arrested her on this warrant from sometime mid-October. So she denies the allegations, and we asked for a signature on bond through the jail with no further restrictions. The warrant states that she made harassing text messages to these individuals who she states that she doesn't know.
All right. Defendant will receive a $3,000 SOB through pretrial. She is to have no further contact whatsoever with the alleged victims in this case and do her best to stay away from their particular units. And when I say no contact, that means via phone, email, social media, or otherwise. If she sees them, she should walk in the other direction. Additionally, she's to have no drugs, alcohol, or weapons as a condition of that SOB through pretrial. Is there anything additional?
Yeah, so if you send it through pretrial, I'm gonna need a level. Just, they need to go on the bond assessment.
I'll do the recommended level.
What I recommend, level 3?
Yes, you told me level 3, which you believe is one. I'd like her to come twice a month, but we
Level 2.
haven't confirmed what, okay, so level 2.
Yeah. Level 3
Okay.
is once a week.
Yeah, no, we won't do that. We'll do twice a month.
So level 2.
We'll do level 2. If there's a sheet that you have with the levels and the meanings, that'd be great. I know you don't have really time to send it to me now, but if you could, Ms. Howard. Any further objections or comments from Mr. Walker or Ms. Atai?
No, Your Honor.
All right. Best of luck to you, ma'am. That concludes your case at this time. Who do we have next?
Position 5, Henry.
All right. Are you Alexis Henry?
Yes, ma'am.
All right. Your case is 23 CR 006949Y. You are charged with criminal trespass. Do you understand your rights? Is that a yes?
Yes, ma'am.
All right. Mr. Howard, the history, please.
So this is her third arrest. She was arrested November 2nd and October 30th for trespass.
Okay.
Yeah.
Mr. Thomas, please proceed.
One moment, Your Honor, I'm pulling it up. I had it. Let's see. Okay, I found it. Sorry, my apologies, Your Honor. This is actually, yeah, as he said, this is her third arrest. Just to give you a brief history of what's going on, it's the exact same location. Looks like on October 30th, 2023, there was an NOD that was done by the state for the same location, which is that Starbucks. And then there's that there's that November 2nd, 2023 Fulton case where she received a $1,000 signature bond from Judge Morrow. But basically, the defendant had a criminal trespass warrant from the location, case number 233-000-536. And upon arrival, the defendant was still at the location after multiple attempts from the staff to get her to exit the property. She still refused to leave. The manager at the location, Ms. Bowden, stated that they wanted to press charges. That location of the Starbucks is 267 Marietta Street, Atlanta, Georgia, and Fulton County, Georgia. Just to kind of give them a break, just because of the obvious risk to reoffend, the danger to, I guess, that particular victim, that victim being the business, the state's going to be requesting a $2,000 surety bond, a no alcohol, drugs, or weapons, and an absolute stay away from that incident location, as this is her third time within literally less than a month being trespassed from said location.
All right, Ms. Abden, your response. I'm assuming, I think she got an SOB jail last week. So, is there anything you'd like to put on the record? Does she qualify for PAD perhaps?
She was referred on the 31st and declined. She also declined misdemeanor mental health court, Your Honor. I did not suspect any MH issues. I did speak with her about this. She did confirm that she will not be returning to the location. She does understand her obligation to abide by the court's order. And she is 30 years old. She has a bachelor's degree from Agnes Scott. She's been living here consistently for 10 years. She's currently residentially insecure and she's not working. And so setting a bond for her today, Your Honor, would be like no bond at all. She doesn't doesn't have anyone who can bond her out or any funds to afford that bond. And I do understand that she was given a signature bond through the jail. She has assured me that she will not return to the location. And so I am requesting a signature bond for her today. And she, like I've been saying, will abide by a stay away.
All right, defendant is going to receive a $500 surety bond. I am going to order a BHET at this time. Additionally, she's to have no drugs, alcohol, or weapons and stay away from that Starbucks location. Is there anything additional at this time?
Nothing else, Your Honor. Thank you.
All right.
Nothing further from the state, Your Honor.
All right. Best of luck to you. That concludes your case. Who do we have next?
Position 13, Turner.
Okay. Good. Okay. Are you Terrence Turner?
Yes, ma'am.
All right. Your case is 23 CR 006959A. You're charged with simple battery against someone who's either pregnant or 65 years old with the offense date of November the 7th. Do you understand, right?
Yes.
All right. Mr. Howard, can I have that history, please?
Fourth arrest, 2021, he got an open case for ag assault, false imprisonment. It's 23 SC 186776. 2018 terrorist threats, 2013 trespass damage. And the level for this was 1.
Okay.
Yes, Your Honor. In this case, law enforcement was dispatched to 3901 Campbellton Road, where they spoke to the victim, Ms. Sharon Ball. That was actually their second time at that location that day due to a dispute. This last location that's before the court, the victim advised that her and her nephew were engaged in a verbal altercation where he became physical and he pushed her in the head. The victim is 65 years of age and they do reside together. The state is asking for a $1,500 surety bond, no contact with the victim, Sharon Ball, and a stay away from the incident location, 3901 Campbellton Road, no weapons, drugs, or alcohol while on bond.
I'm sorry, is it Ball or Vaughn? What is the last name?
Baugh.
Ball. Okay. Is Ms. Ball present and wishes to make a statement? Let me scroll over. I don't see that name. Ms. Kim, please proceed.
Yes, Your Honor. My client, Mr. Turner, is 31 years old. He was born and raised here in Georgia. He has a strong ties to the community. And Your Honor, his entire family is here. He's not a flight risk. Indeed, he's trying to get a job and he was supposed to have an interview about 2 days ago at the local church. However, he was arrested and he could not get the job, Your Honor. So he is qualified for public defender services, and even $1,500 surety bond means almost like no bond for him. Your Honor, he is willing to stay away from the location. He is willing to have no further contact with her aunt and uncle, as long as he gets he's willing to do like 4 times a month the pretrial report, as long as he gets out of the jail through the signature on bond. So we ask for a signature on bond through a pretrial, Your Honor, and he has 1 child that he has to take care of as right now. So that's it, Your Honor.
All right. Defendant will receive $1,000 surety bond. He's to have no contact with the alleged victim and stay away from that location. He can return 1 time with a member of law enforcement to get any items, and he should have no alcohol, drugs, or weapons as a condition. Is there anything additional?
No.
Yes, can I say something on his behalf?
No, not at this time. The only people that are allowed to speak today are the direct victims of the case. Are you a victim, sir?
No, she was with me, but we just parted. She was up at the courthouse now trying to speak to somebody on the situation that happened.
Well, what we can do is, I think there might be is there a victim witness advocate on the line? Can someone give Mr. Murray some contact information whereby the victim can get some assistance? But at this time, I'm not sentencing the defendant, so other witnesses are not essential to the process today. Okay. If you don't get in touch with somebody at this proceeding, Mr. Murray, give the solicitor's office a call and ask for a victim witness advocate. All right.
Okay.
All right. Best of luck to you. And that concludes this. All right. Who do we have next?
Position 14, Webb.
All right. Are you John Webb?
Yes, ma'am.
All right. Your case is 23 CR 006955E. You're charged with battery. Do you understand your rights?
Yes, ma'am.
Mr. Howard, please proceed.
49 total. 2023 shoplifting conviction. 2023 criminal damage to property open. 2023 trespass no low. 2022 probation. Shoplifting conviction from 2022 obstruction. 2021 theft by taking probation. 2020 probation. 2019 simple assault theft by taking conviction. More probation violations.
That's sufficient. Thank you, Mr. Howard. Mr. Walker?
Yes, Your Honor. The victim, whose name is Corey Anderson, reported that she was walking down the street on Ponce de Leon. When she passed the defendant on the sidewalk, he blindsided her out of nowhere and punched her in the face with a soda can. And we are referring this case to the DA's office. The victim did have to receive treatment, and she had to receive stitches to her face. Based upon the facts of the case and the defendant's lengthy criminal history, we are asking for a $4,000 surety bond. No contact with the victim. Corey Anderson, no weapons, drugs, or alcohol while out on bond.
All right, I'm sounding for Corey Anderson at this time. If you wish to make a statement, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
I am not sentencing the defendant today. There will be other proceedings whereby you'll be able to give your rendition. So if you disagree with anything Mr. Walker said, that's not of critical importance to me. What's critically important to me today is any concerns you have for your safety. And that's primarily what I wish to hear. I'm sure you will have other opportunities to speak regarding this. Again, he is entitled to a bond because this is a misdemeanor offense. What would you like to tell me in light of those instructions?
I live in the Little Five Points neighborhood, and I've lived there for 30 years. And there are a lot of people with homeless challenges in that neighborhood. I've never had anything like this happen before, ever. I understand that Mr. Webb continues to hang out in that neighborhood. I've heard from other people, the police and shop owners, who say that he continues to be around. I believe that he had another arrest about a month ago for shoplifting in that area. And I would like I would like to be able to be in my neighborhood and not be afraid that he's around, either for myself or for other people.
Your Honor, I would like to make an objection to any previous incidents or any other people who were involved in any other cases. So those are all hearsay and irrelevant, Your Honor.
Okay.
That directly goes
wait, one second. Thank you. I appreciate you coming to court and making that statement. I am assuming that you wish to have no contact whatsoever with this defendant. Okay, just wanted to clarify that for the record. Mr. Walker, I know, yes, we allowed the victim to put the full testimony onto the record. What I consider will be up to me, but I will consider it in accordance with the law. All right. Ms. Kim, please proceed.
Yes, Mr. Webb is 35 years old and he was born and raised here in Georgia. And he does have parents' address in Marietta. So he's not homeless, actually. Your Honor, I would like to request for signature on bond. Even though he is working at Dollar Tree, he is having financial challenges. He graduated from high school, and honestly, he does not remember any incidents like this. Actually, he doesn't remember. This happened on September 6, 2023. He doesn't even know Miss Corey Anderson. I don't think he is the one, so he's denying the allegation. Thanks, Your Honor.
All right. Defendant will receive a $2,500 surety bond. He's to have absolutely no contact with the alleged victim, whether through social media, email, phone, text, anything. He should stay away from that incident location. Additionally, he's to have no alcohol, drugs, or weapons as a condition of that surety bond. Is there anything additional from the state or the defense?
Yeah, and I would ask the court to consider a BHET at a minimum. I mean, this was the unprovoked attack, so.
He's received a surety bond, Mr. Walker. I'm not going to order the BH at this time. All right, but I do note the state's concerns and objections.
Okay.
And he perhaps can be revisited. It doesn't sound like he's gonna make bond right away. I don't know. Ms. Kim says that he does have family. If this needs to be revisited at SAP, we can. All
Okay,
right.
thank you.
Thank you, Your Honor.
All right. Best of luck to you, sir, and thank you, Ms. Anderson, for coming to court. All right, who do we have next?
Position 10, Richardson.
Okay, position 10. Are you Orion Richardson?
Yes, ma'am.
All right, in this case, 23 CR 006958, you're charged of theft of lost or mislaid property with the offense date of November the 7th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
27 total, 3 shoplifting convictions from 2019, 2023 failure to appear, obstruction, shoplifting, possession of marijuana, financial transaction card theft, theft of lost and mislaid property. 2022 shoplifting, 2021 and 2020 shoplifting. It said level 2. But yeah, that's it.
Yes,
Mr.
Your Honor,
Walker.
law enforcement was dispatched to 180 Ponce de Leon Avenue for the defendant loitering at that location. Upon arrival, the officer did speak with a security guard who advised that the defendant was parked in their parking lot without reason. The defendant was actually asleep in the car with the keys on his lap. Upon making contact with the defendant and running the tags or running the license plates on the vehicle, the license plates came back as stolen. At that time, warrants were taken out for his arrest. The state is asking for a signature bond through the jail. No weapons, drugs, or alcohol while out on bond.
What was that location where he was in the car?
I
Do we
just
know
have
that?
the address is 180 Ponce. I can try to look it up.
Okay, that's okay. I was trying to make sure it wasn't something medical. But you did not request to stay away, correct?
It's a Chevron.
Okay, I don't think he needs to go back there. Ms. Kim, in light of the information before me, I'm inclined to grant that SOB through the jail with a stay away from that location. Do you have any objection or anything additional you'd like to add to the record?
No objection, Your Honor. Nothing further.
All right, in light of the information before me, defendant will receive a $4,000 SOB through the jail. He should stay away from that location on Ponce de Leon and have no alcohol, drugs, or weapons as the condition. All right, best of luck to you. That concludes your case. What do we have next?
Position 9, Postal.
Okay, are you Deterius Postal?
Yes, ma'am.
Your case is 23 CR 006956J. You're charged with giving false information to a law enforcement officer. Do you understand your rights? Is that a yes? I'm assuming that's a yes. Mr. Howard?
Yes, ma'am.
11 adult arrests. I see probation holds. 2020 possession of marijuana, drug-related objects, possession of a controlled substance, possession of a carrying concealed weapon. 2020 battery DV, 2020 carrying a weapon without a valid license, theft of lost and mislaid property, 2019 probation, 2018 possession of a firearm by convicted felon, 2015 burglary, first offender, 2015 theft by receiving, first offender. Said level 2.
Okay, thank you. Mr. Walker?
Yes, Your Honor. In this case, law enforcement was dispatched to 1033 Hollywood Road due to a dispute call. Upon arrival, they met with the defendant who was engaged in a verbal altercation with his girlfriend or the mother of his child. During the course of the investigation, the officer asked for the defendant's name. He gave the name of McQuavis Pastel, who was determined to be his little brother and not him. Upon ascertaining his actual identity, it came back that he had multiple warrants out of Fulton County. At that time, a warrant for giving false information to an officer was taken out. The state is asking for a $1,000 surety bond, no weapons, drugs, or alcohol while on bond.
All right, Ms. Kim, in light of the information before me, I'm inclined to give the defendant a $2,000 SOB through the jail. Do you have any objection to that?
No objection, Your Honor.
All right, defendant will receive a $2,000 SOB through the jail. He is absolutely not to have any alcohol, drugs, or weapons. Is
Thank
there
you.
anything additional?
Nothing further from defense.
All right, best of luck to you, sir. What do we have next?
Position number 4, good afternoon, Your Honor, ACDC.
Hold on, Miss Milton, I was talking. Position 6, Miller.
Has ACDC heard their rights? No. All right. Officer Milton, they haven't heard their rights. We'll do 6 very quickly. Are you Tariq Miller?
No, not that. Yes, ma'am. Yeah.
All right, your case is 23 CR 006950F. You are charged with battery, family violence, and cruelty to children in the third. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
So this is Miller.
Yep.
Fifth arrest, 2019 simple battery dismissed. 2016 shoplifting first offender. 2015 possession of marijuana conviction. 2013 shoplifting level 1.
Okay.
Your Honor, brief facts of the case is that the victim reported to the Atlanta Police Department on August 8, 2023, an incident of assault. She stated that the assault took place by the defendant during a verbal dispute. The victim stated that the defendant hit her, causing her phone to hit her mouth. Afterwards, she stated that they argued and tussled until the police arrived. The defendant ran from the scene when police showed up. The victim stated that her 11-year-old daughter, initials A and S, was in the apartment when the assault happened. She stated that her daughter heard the argument but did not see the assault. The victim suffered a visible cut to her upper lip and her shirt was torn, and that's what the officers observed. That incident location is 178 Maury, Moury Avenue Southeast, looks like unit number 3615, Atlanta, Georgia. The victim's name is Raquel, Raquueshel, Lattimore, traditional spelling Latimore. The recommendation from the state, Your Honor, is a signature bond through the pretrial services, no alcohol, drugs, or weapons, no contact with the victims, a stay away from the incident location, and the completion of a family violence intervention program.
Okay. Is Ms. Lattimore present and wishes to make a statement?
Yes, I'm here.
All right, you need to turn on your camera, raise your right hand. Do you, sir, please invoke your right to remain silent. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. I am not sentencing the defendant today. What I'm most concerned with are any concerns you have for your safety and if you wish to have contact. In light of those instructions, what would you like to tell me?
I do not. I feel safe around him. He is not a flight risk to me. In light of what was sent to your private DM, there's a reason why we do have to be in contact. I'm not sure.
I don't read my private DMs. That I don't know what you're referring to.
Your Honor,
Okay.
I sent you something in the chat that she wanted to share.
Okay, well, that's not appropriate, Mr. Tay. I'm sorry. I don't read. I personally get too many of those and I don't read what's in the chat. If we need to go into a breakout, we can do that quickly if there's something that needs to be said off the record. But I purposely don't read those because I don't want it to get into the place of having any ex parte communication with anyone. Okay, so if we could very briefly be placed in a breakout with Mr. Ty, Mr. Thomas, Mr. Walker. I believe Ms. Kim will want to come and Ms. Abden is welcome. And sir, please put your hand down and avail yourself of your right to remain silent.
Your Honor, I think I need to be in there as well.
You and I are one, Miss Bridgewater.
Always.
I just assumed that you were coming with me.
Can I be added to the breakout room as well, please?
All right. I'm sorry. And okay, Mr. Thomas was finished. I did hear from the attorney, Miss Lattimore. Is there anything else you want to say on the record?
No, but I'm
Okay.
fine. My child is fine. He's not a flight risk to either of us. We've been cohabitating for the last few months. Just that was our first incident, so but I'm fine.
All right. Mr. Ty, please proceed.
Your Honor, my client is 27 years old. He works, he's been working a steady job for the last 1 to 2 years with Amazon. He denies the allegations in the warrant. He states, and
I'm sorry, I don't mean to interrupt. I want to make sure we're on the right case because Mr. Miller is saying this is not him, and then you have Ms. Hoda, the age is not correct. Are we on Tyree Miller?
Okay, what is your alleged date of birth, sir?
08/24/1996. You read
Yes.
out charges that weren't mine.
Yeah, there's an issue with the I guess the booking sheet or the warrant that it states somebody born in 1984.
Okay. Mr. Howard, can you rerun the history based on that or no? With the new DLB.
What's the date of birth?
It should be 96 instead of 84.
The full date of birth.
08/24/1996.
I have 1984. Did you guys need the booking number?
So he was born in 96, but the
That's
booking
what
says
he's
84?
saying. Correct. They're saying the booking is incorrect. He's born in 1996.
Ian, what you got?
I'm looking at it now.
Hold on.
So I have on the GCIC, it lists both birthdays. It lists August 24th, I'm sorry, August 24th, 96 and August 24th, 84.
Okay. So you believe the GCIC reflects the accurate history despite the discrepancy in the birthdays?
I do believe so.
No,
Anybody else?
incorrect.
No. Do not speak.
That is
Do not
incorrect.
speak.
That is not my stuff.
Okay, I need you to stop talking. Stop talking.
Stuff.
Stop talking.
What is going on?
Please mute.
So
Not today.
The first
Go ahead.
name is Tyreek, Tyrek.
Yes. Mr. Miller, we are going to rerun the GCRC, okay? Just relax.
Ooh.
We're going to make sure I'm talking to the defendant. He's very concerned. We're going to make sure we get the right history.
Well, it's the right history. Because the name says Tyreek LaShawn Miller. And I'm looking at the names for each cycle of arrest. So it's the same name that's on here.
And Jan, I'll just point out that the recommendation from the state was a pretrial services signature bond.
That doesn't mean that's what I have to do, Mr. Thomas.
That's correct, yeah.
So, well, hold on.
So that's why the history is important. Huh? I'm sorry?
Does Tucson need the booking number? Tucson?
He says wrong, the information. What's the last four of the social?
2929.
Okay, that's the correct GCIC.
It's correct.
Yeah.
All right. So we've confirmed that's the correct history as stated in the GCIC.
It's just that date of birth produced twice in two different date of births, I guess, on the GCIC, which is not common, but it's this.
Okay. All right. What was the let me go back to this. I want to look at one thing before I decide. All right. Defendant will receive a $2,000 surety bond. He's to have no contact at this time with the alleged victim and stay away from that incident location. Of course, contact can be revisited at a later date, particularly at the SAP calendar. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything additional?
Nothing
Your
further
Honor,
from the state, Your
write
Honor.
that bond down. It's two charges.
1,000 each count.
Thank you.
All right. Best of luck to you, sir. That concludes your case. Who do we have next?
Position 7, Morel.
All right. Are you Dexter Morrell?
Yes, ma'am.
Your case is 23 CR 0069553B. You're charged with simple battery, family violence, hindering a person making an emergency call, and obstruction. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have the history, please?
Second arrest, all he has is a trespass, level 1.
Okay. All right. Mr. Thomas, please proceed.
Your Honor, not so brief, but brief facts of the case. On November 7th, 2023, the officer was dispatched to a physical domestic dispute at the location of 1346 Grand Cirque Drive, Unit D in Roswell. The officer spoke with the witness, Dexter Morrell Sr., the witness who is the father of the defendant. The witness stated that his son, Dexter Morrell Jr., the defendant, who is the defendant, and his girlfriend, the victim, were arguing and fighting inside the apartment. The victim came to the door and stated that she woke up the morning and asked the defendant to take care of their 1-year-old son, MJ. The defendant replied that he was tired and that he was not going to get up. The victim stated that they started arguing and that he threw a bag of baby bottles and hit her in the face, the left side of her face to be specific. The victim stated that the defendant snatched the phone out of her hand while she was trying to get in contact with the police, specifically the 911 dispatcher. The officer attempted to speak with the defendant, who advised that he did not want to talk. The defendant advised that he was advised that he was being detained while the officer was completing their investigation. The defendant began to run around the parking lot with the minor child, MJ, in his hands. The officer asked the defendant to stand still, but he refused to stand still. Again, minor child still in his hands. While holding the minor child, the defendant started running back into the apartment and ran through the house and out of the back sliding glass door. While holding the minor child, the defendant then entered a storage closet that was in the back patio and shut the door. The defendant continued to resist arrest, and eventually the minor child had to be pried from his hands. Our office has not been able to get in contact with the victim. That particular victim's name is Alaina, Alaina Jenkins, traditional spelling. The recommendation from the state is a signature bond through the pretrial services, no alcohol, drugs, or weapons, no contact with the victim, a stay away, and the completion of a family violence intervention program. And if we could sound for the victim at this time in accordance with Marcy's law, that'd be greatly appreciated.
All right. Is Ms. Jenkins present? I don't see anyone with that name. Mr. Ty, please proceed. I'm inclined to grant that signature bond through pretrial with the stay away and no contact. Do you have any objection to that or anything additional you'd like to add to the record?
I would just like to, the signature bond is fine. My client is 22 years old. He's a manager at Taco Bell for the last 2 years. I also wasn't able to get in touch with Alaina Jenkins. He denies the allegations, states that the complaining witness was the first aggressor who threw something at him. He does have a 1-year-old son with the complaining witness, so we would ask.
That's not me.
Okay, please mute if you're not Ms. Jenkins. So you're asking for a third-party transfer of the child?
Yes.
Okay. Let me pull that back up. Defendant will receive a $3,000 SOB through pretrial per judge at the recommended level. He is to take the 1-day anger awareness course and have no contact with the alleged victim. He can coordinate transport of the child through a third party. Additionally, he must stay away from that location and have no alcohol, no drugs, or weapons. Is there anything additional?
Nothing further from the state, Your Honor.
All right.
Is that $1,000 on each charge?
Yes, ma'am. I apologize. Thank you, Ms. Polly, for keeping me honest. Sir, if you have a question, the best thing for you to do is to speak to Ms. Atai. I don't want you to, by mistake, say something that will impinge upon your right to remain silent. Okay?
I'm sorry, Judge, what was the bond amount?
$3,000 SOB through pretrial.
I was just asking why my bond somehow sound broke right now.
Okay, you're done.
Holly, that was level one.
Level one.
So I don't know what that means either. Is that for a judge?
Once a month. It's not, everybody appears to be recommended now. It's just the level at which they're going to be
I'll
recommended.
mark it level one. Okay.
With that being said, there are no more per judges.
Thank you, because I'm totally in the dark on this. Level
I'm starting to come to the light with this, so I ain't too far from it, but okay.
Okay. Thank you.
All right, who do we have next?
Position 2, Boyette.
All right, are you Kyle Boyette?
Yes, Your Honor.
Your case is 23 CR 0069518H. You have a seatbelt violation, a DUI, and driving while your license was suspended. You understand your rights? All right, Mr. Howard.
Yeah, there.
Fourth adult arrest, 2022 failure to appear, 2022 suspended license NOLO, and a 2017 suspended license. The level on that one is a 1.
Okay. All right, Mr. Thomas, please
Your
proceed.
Honor, brief facts of the case is that the defendant was operating a vehicle. It looks like at 100 Creekside Way in Roswell. The accused was not wearing his seatbelt at the time. The officer conducted a traffic stop on the defendant. The defendant had a heavy odor of alcoholic beverage on or about his person, specifically his breath. The defendant had a red, watery eyes, slurred speech, and any circular sway. While standing, the defendant failed a field sobriety test. A chemical test of his breath was conducted. The accused had a suspended license for 2 failure to appear charges. One on looks like November 1st. Sorry, no, looks like November 17, 2020, and August 10, 2021. Your Honor, given the history and the facts, the state will be requesting a $3,000 surety bond, no alcohol, drugs, or weapons, no driving unless authorized to do so with a valid license.
All right. And who represents this? My screen scrambled. Is this your case, Ms. Abden?
Yes,
All
Your
right,
Honor.
thank you. Ms. Abden, please proceed.
Thank you. So I am requesting a signature bond. He is recommended through pretrial, and he is 27 years old. He's lived in Georgia his whole life. He's currently living with his parents who live here in Georgia. He has 2 brothers here in Georgia, so he has strong ties to the community, and he's not a flight risk at this time. He graduated from high school and attended Georgia State for 4 years, where he studied actuarial science. He is gainfully employed. He does Uber Eats on a bike, Your Honor, so he would not be driving. And he's been doing that for about a year. I do understand he does have 2 prior FDAs. I looked up those cases. It looks like he's appeared since then, Your Honor. I did discuss this with him. He's assured me that he will return to court for his next court date and will abide by any conditions the court deems necessary today. He does have a very low income, so his indigency is a concern. Setting a bond for him would be like setting no bond at all. So I am requesting that Your Honor consider setting conditions that are reasonably necessary to ensure that the public is safe, but in lieu of setting a bond, because he will not be able to make that. And he actually did try to get his brother to make the bond that was set. I think it was 3,000 is what it is set at right now. And his brother was unable to do that. So I am requesting a signature bond. You're muted.
All right, thank you. Defendant will receive a $3,000 split bond. It's 1,000 SOB through the jail for the seatbelt violation, 1,000 surety for the DUI, and 1,000 SOB through the jail for the driving while the license is suspended. He's absolutely not to drive unless he has a license or permit issued by the Georgia DDS. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything additional?
Nothing further from the state, Your Honor.
All right, best of luck to you, sir. That concludes your case.
Thank you.
Position 3, Brown.
And Your Honor, is this is he being represented by private counsel? I do see.
Yes,
Okay.
Attorney Jackson Blake Store for Mr. Brown.
Okay, thank you.
All right. All right. Mr. Brown, your case is 23 CR 006947G. Your case, you're charged with battery against a pregnant female, battery on an unborn child, and battery family violence. Do you understand your rights?
Yes, ma'am.
You say, is that a yes?
I said, yes, ma'am.
All right, thank you. Ms. Howard, can I have history, please? Okay, I got you.
All right, third arrest. Last was in March out of Marietta, sale of marijuana that's open. And what I put in the chat for you, the capital offense out of St. Louis. That's it.
Okay, Mr. Thomas?
And Your Honor, just briefly, I know it's a wave sounding, but we state that he received a 10-year sentence on that. And that was sentenced in 2015, by the way. But brief facts of the case is on October 30th, 2023, the officer responded to the incident location in reference to a report of an assault. That incident location being 165 Sawgrass, traditional spelling Drive, south of Fulton, in Fulton County, Georgia. The victim was observed to have several visible injuries. The officer observed a large knot onto the right above her left eye, another knot on the right side of her right eye, a bruise to her nose, multiple lacerations to the inside of her mouth. The victim stated that she was just beaten up by her child's father, who was the defendant. She also advised that they lived together at that location. She expressed that she was 9 months pregnant when and was experiencing pain on the top left side of her belly due to the defendant striking her an unknown amount of times at that location with a closed fist. She advised that she was laying in the bed upstairs prior to the incident, and they got into a verbal dispute because she denied him the use of her vehicle, and the defendant immediately became aggressive towards her, jumped on top of, immediately became aggressive towards her, made statements to her such as F you and that baby. The victim advised that after the verbal altercation, the defendant then climbed on top of her while she was laying in bed and struck her several times in the face with a closed fist. The defendant stated that the victim, while doing this, the defendant stated to the victim while doing this that he would kill her and the baby. The victim advised that she was struck several times with a cell phone as well. She also stated that the defendant saw that she was on the phone with the police, and so he ran out the back door. Upset that she had even called the police, he later texted her that she can't come back from that. The victim was then transported to the hospital. Our office has been able to get in contact with the victim. Looks like her name is Brymeisha, Brymeisha, Turks, traditional spelling Turks. She advised that they have lived together for approximately 4 years and have a baby on the way. The defendant has since moved out since the incident and is currently living with his mother. I guess, so the state's request for a stay away should be okay. But the defendant, the victim states the defendant has been verbally and physically abusive to her throughout the relationship, and she does fear him. This is the first time that she has, however, called the police. She confirmed the events that were in the warning. She said that she went to the hospital and that they kept her overnight because she was having contractions due to the defendant punching her in the stomach. She does want a no contact and a stay away. And I do believe that this case itself is a possible DA transfer. And so with that being said, given the open case in Fulton, given the 2015 10 years sentence on the wave sounding case, the state is requesting, and obviously the danger to the victim in this case, we don't want him to make good on that promise of killing her and or the baby. The state's recommendation is a $10,000 surety bond, no alcohol, drugs, or weapons, no contact with the victim, a stay away from that location, and the completion of a family violence intervention program. And if we could please sound for the victim at this time, Ms. Turks, and according to Marcy's law, that'd be greatly appreciated, Your Honor.
All right, is Ms. Turks present and wishes to make a statement? I see someone with that first name. Ms. Turks, you are not required to make a statement, but if you wish to, please turn on your camera, unmute your screen, and raise your right hand. Okay, I'm going to assume Ms. Turks does not wish to make a statement. Ms. Blake Stewart, please proceed.
Yes, Your Honor. Mr. Brown is 30 years old. He currently is living with both his mom and dad in Marietta. He's currently working as a caregiver at Loving Care with Hands. Your Honor, my client does deny the allegations of the complaining witness. He is not a significant risk of flight. Mr. Brown, once he knew about the warrant, he did retain counsel and turned himself in immediately. He is not a significant risk of intimidating any witnesses. Yes, he has a baby on the way. I would ask that there is a no violent context, so he is able to appear and be there if allowed for the birth of his child. He does have an open case in Marietta, which he has court on that on tomorrow, in which that will be a probation case. Your Honor, I will ask that bond be set at $5,000.
All right. Defendant is going to receive a $7,500 surety bond, $2,500 on each count. He's to have no contact with the alleged victim, stay away from that location. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Should this bond be pending and not be resolved prior to the birth of his child, he can arrange transport of that child later with a third party. And of course, contact can be revisited at a later date. Is there anything additional from either the state or the defense?
Nothing further from the state, Your Honor.
Nothing further, Your Honor.
And Ms. Stewart, does that conclude your business?
Yes, it does.
Looking forward to seeing you around the neighborhood. Take care. Good to see you as always. Bye-bye.
Bye-bye.
All right. Who do we have next?
Judge, I have a couple of announcements. For position 1, it's going to be a medical reset.
Okay.
And then we also have ACDC position 4, Ms. Flowers.
All right. Has ACDC heard the rights? I'm going to assume not. Ms. Flowers, your case is 23CR006948G. You're charged with false report of a crime. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney today. I'm conducting this proceeding over the internet as a live stream. It's also being recorded. Do you understand your rights and how I'm conducting the hearing today?
Yeah.
All right, Mr. Howard, can I have the history, please?
Third arrest, 2014, disorderly conduct, level 1.
Okay. Whose case is this for the state? Nobody?
I'm sorry, I had my thing on, but not my video. I'm going to
Okay.
go over the facts just to let you know that the recommendation is a signature bond to the jail, but I'm going to go over the facts just because of the nature of the charge. But the facts are essentially that on November the 7th, 2023, officers were dispatched to the incident location in reference to a fight call. The 911 dispatcher advised that the defendants contacted 911 to report that her son, the victim, Rodney Smith, would not leave the residence and that she wanted him to leave. The defendant stated that the victim was threatened. Once the officer got there, the defendant stated that the victim was threatening to shoot her. The defendant displayed slurred speech and appeared to be inebriated. The victim stated that he did not threaten the defendant and provided video footage of the defendant ranting and causing a disturbance at the residence while the occupants were resting in their rooms. The officer also spoke with the victim's brother, who stated that the defendant repeatedly knocked at the door while they were trying to sleep, and this is a common occurrence when the defendant drinks alcoholic beverages. The officer then advised that there is insufficient evidence for the charge and that he was not going to file it, and that he advised the defendant that reporting a false crime to 911 is a crime. The defendant then advised them to separate, and I'm sorry, the officer then advised them to separate and left. Later that day, she contacted the 911 again and reported that the victim had put a gun to her head. Upon officers arriving for a second time, the defendant stated that the victim was jumping around on the couch and lived in the living room with a gun to his head. The defendant never stated that the victim put a gun to her head while the officer was on the scene. The victim then provided video footage that showed the defendant ranting and yelling in the residence. The victim advised the defendant had been reporting false crimes because she wanted him to leave the residence. Yet again, a third time, the officer left, but the third time the officer came back. And later that day, and because the defendant had contacted the police again, the 911 dispatcher advised that the defendant reported that the victim was trying to kill her. Upon arrival, the defendant stated that she did not want the police assistance anymore and stated that she called 911 to tell them that no one no longer needed the services of 911. The officer then spoke with the victim, who appeared to be asleep in the room, who stated that After he left the last time, they didn't even have contact at the residence. As I stated earlier, Your Honor, the recommendation is a signature bond through the jail, no alcohol, drugs, or weapons, no contact, and a stay away. I just wanted to put the indicia on the record. But if we could sound for the victim, looks Rodney Smith, traditional spelling in accordance with Marcy's law, and the incident location is 5500 Oakley, traditional spelling, Industrial Boulevard, apartment 610, South Fulton, Atlanta, Georgia 30213.
All right, is Mr. Smith present and wishes to make a statement? All right, hearing none, Mr. Ty, I'm inclined to grant that SOB through the jail with a no contact and a stay away. Are there any objections or things you'd like to add to the record?
Yes, Your Honor. My client is a 46-year-old mother of 4. She has a 16-year-old and an 18-year-old and and this 25-year-old son who recently moved into her home, but the 16-year-old and the 18-year-old permanently live with her. She denies the allegations. She states that and also we object to mention of a victim in this case. She's been charged with false report of a crime, so there is no victim in this case. She's charged for calling 911, and she denies that she made any false report. She's calling because she's concerned with the 25-year-old who's now living with them, constantly having guns around the house, always having them out around her 16-year-old and 18-year-old children, one who is a 10th grader in high school. And according to Georgia law, she does have a right to exclude someone from the property that she's on the lease. And so we strongly object to a stay away from the 5500 Oakley Industrial Boulevard since it's her home, and she does have a right to exclude him from her property when he is carrying a gun. And especially in the interest of her 16 and 18-year-old children that are living in the home. So we object to the stay away. She called the police and the police arrived, and according to the warrant said, well, he has a right to have a gun in your home, and that's not true.
I'm sorry, the last part, you have a right to have a gun, but that
the officer stated to her that he has a right to have a gun out in the home, and that's not the case. The officer did not address her complaints. There was no false report. She was calling to say that it's her home. She's the only one on the lease. And if she has to stay away, then the 16-year-old and 18-year-old will also have to move out of that home. So this 25-year-old who insists on having guns out and loose in the home can continue with that, which is not, he can't do that. She has a right to exclude him.
Understood. All right. In light of the information before me, defendant received a $5,000 SOB through the jail. I am not going to require the stay away based upon the charge as presented. Additionally, she's to have no drugs, alcohol, or weapons as a condition. Is there anything additional?
No, that's all, Your Honor.
Nothing further from the state, Your Honor.
All right. Best of luck to you, ma'am. That concludes your case. Is there an announcement for position 11?
Yes, for position 11 is going to be waive of appearance.
Okay. All right. We will now take up the courtroom 2 can be excused as ACDC as well. We will now take up the case 23CR006960J, Thomas Sherrod, in which the defendant is charged with simple assault. Mr. Hart, can I have the history?
47 total. He was arrested 4 times last month, October 1st, 10th, 14th, and 24th. Trespass. He got a probation violation from this year, last year, failure to appear from 2022, 2021 probation. On probation, possession of cocaine. It's 18 SC 160625. Yeah. So he got those open cases and the probation.
All right. Mr. Walker?
Yes, Your Honor. In this case, law enforcement officers were walking down John Wesley Dobbs Avenue when the defendant approached them, following up his fits and saying, "I'm going to beat your ASS," and referring to the officer as a racial slur, threatening him. The defendant refused to stand down at that time. The officer did take out a warrant and arrest him for simple assault. As pretrial stated, this is the defendant's 5th time being arrested since October. I've even personally dismissed a couple of those cases. The state does have grave concern about the defendant's mental health. So with that being said, we are asking for a $1,500 surety. We are asking for MHET, no contact with the officer. I believe the officer's name is D. Peters, no weapons, drugs, or alcohol while out on bond. And again, we are asking for an MHET based on the number of arrests in a short period of time, and they all seem MH related.
No, Ms. Kim?
Yes, Your Honor, about the no further contact with the officer, I don't think it is possible for my client because there's officer has to carry out his duties. So we would like to request for no further violent contact for the sake of the officer. Other than that, we have no objection, Your Honor.
All right, and you don't object to the evaluation either?
No.
All right, we will accept the state's recommendation in its entirety with the exclusion of the contact. It'll be no further violent contact. Defendant will receive a $1,500 surety bond. He's to undergo evaluations, have no further violent contact with the officer, and have no alcohol, drugs, or weapons as a condition. Is there anything additional?
Nothing further, Your Honor.
All right, I believe we've completed the entire calendar. Ms. Bridgewater, will you please review it for me?
Okay, once again, the reset date for the SAP calendar is November 21st. Position number 1 is being reset till tomorrow for medical reasons. 2 is going to the SAP calendar, which is a $3,000 split bond. 3 is going to the SAP calendar with a total $7,500 good bond. Position 4 is reset further notice with a $5,000 SOB through the jail. 5 is going to the SAP calendar with a $500 good bond. 6 SAP calendar with a total $2,000 good bond. 7 is being reset further notice with a total $3,000 SOB through pretrial. 8 reset further notice with a $3,000 SOB through pretrial. 9 reset further notice with a $2,000 SOB through the jail. 10 reset further notice with a $4,000 SOB through the jail. 11 is going to the SAP calendar with a $1,500 good bond. 12 is going to the SAP calendar with a total $2,000 split bond. 13 SAP calendar with a $1,000 good bond. And 14 is going to the SAP calendar with a $2,500 good bond. Are there any questions, comments, or otherwise?
Nope.
All right, hearing none, we'll be in recess until tomorrow's SCA calendar, at which time Judge Law will be presiding. Take care, everyone. Have a good day. Bye-bye.
Thank you all. Take care.